Good morning. I am Tracy Perry. I am the clerk of the courts, and I want to welcome you today to our first guardianship audit presentation, I guess you would call it. I'm going to introduce a few people in the room just so that you have an idea of who our panelists are, who's going to be speaking today. I also do want to let you know that there is going to be a portion of this session that will be questions and answers. So if you could hold your questions until we get to that portion, it would be greatly appreciated. And this is also being recorded, just so that you are aware. It is only being recorded from the podium and upwards, but the questions and answer session and the presentation will be recorded today. Lastly, well, as I do introductions, let me first introduce Lori Parrott, who many of you may be aware of. She is our guardianship auditor. She is going to be retiring. And so I invite all of you who would like to remain after the presentation to stay. We're going to do a small celebration for Lori and wish her well in her new chapter. So with us today, I have Robin Barclay, who's our Chief Internal Audit Officer. I have Judge Spate, who will be presenting some to you. I have Sonia Parlepa. She is our probate clerk. We also have Edith Carrara. She is down. Sheila Johnston is one of our internal auditors. Rob Burns. We have Ashlyn Russ, who is our public information officer. We have from the sheriff's office, Mr. Rick Carlson. And then we have Heather Pollard, who is our civil manager, who is over probate, and Natasha Brooks, who is the director. So with that, we are going to go ahead. I'm going to turn it over to Judge Spate and let him start with a quick introduction.
Okay, thank you, Tracy. So first, I want to thank everybody for being here today. Whether you're a person who is currently serving as a guardian, person who might be interested in serving as a guardian, in either a personal or professional capacity, a person who has a situation going on in their life where they think a guardianship might be appropriate, or an attorney who wants to find out more about the guardian process. I want to just thank you all for being here today. Thank you, those who are currently serving as guardians, for the tremendous service that you're doing for the ward you serve and for our community. So I want to start off just by giving you a little bit of background about the process from my perspective. So the guardianships that I see tend to basically fall into one of three categories. First are the guardian advocates. Now, the major requirement for guardian advocacy is that it has to involve a person with a developmental disability. So if the alleged incapacitated person doesn't have a developmental disability, then the guardian advocacy is the wrong lane to be in. Most of these cases involve individuals who have developmental disabilities who are about to turn 18, and the guardian advocates are generally filled by the parents who are continuing to do the same role that they've done for the past 17 years and 11 months. But now they need to take over as the developmentally disabled person reaches adulthood. Then we have the guardian of minors cases. Those come in two forms. One is the guardianships you usually think we're taking on sort of a parental relationship. Those don't usually come through the guardianship process, though. Those are usually handled in dependency court. I've in my 2.5 years on the probate bench, I've seen, I think, 2, maybe 3 that have come in through the guardianship route. The guardian of minors cases that I deal with mostly involve minor settlements. A child either gets an inheritance or is involved in a lawsuit and inherits money or gets money. There is a process where the parent is required to submit reports to the court periodically to oversee the funds. If you have questions about that type of case, we'll talk about that later. But the type of guardianship case that I expect most of you are here for today on is guardianships of an incapacitated person. So those cases generally involve older individuals, many of whom suffer from a condition like dementia or a related condition, who are simply no longer able to take care of themselves. And this can manifest itself in a number of forms. Lots of times it's financial. Vulnerable adults can easily become targets for scammers, or they simply can't manage their finances, their personal finances any longer. Oftentimes someone is needed to step in and make healthcare decisions for somebody that can no longer make those decisions for themselves. So the legislature has made it very clear that adjudicating a person to be totally incapacitated and in need of a guardian deprives such person of all of his or some of his or her civil and legal rights. And there's an established process for the courts to decide whether rights need to be taken away. And we have to determine what is the least restrictive form of a guardianship that's available to meet an individual's needs. So we'll talk about that process. First, a petition is filed. A petition can be filed by any competent adult in order to determine another person's incapacity. Sometimes it comes from a family member. Sometimes it comes from the facility where the person is living, like an assisted living facility. And that petition asks me to declare the person to be incapacitated and to appoint a guardian to act on that person's behalf. Now, once the petition is filed, I appoint an attorney to represent that alleged incapacitated person. And I'm required to appoint an examining committee, which consists of 3 individuals, one of whom has to be a physician. And the examining committee members will conduct an evaluation and report back to the court. And when the petition comes in, we generally set a hearing about 45 to 60 days out in order for the examining committee to do their work and for the attorney to be able to meet with the person and to submit a report back to the court. The attorney is essentially my eyes and ears. They go out and meet with the person at their facility. They are required to read a copy of the petitions to the person to the extent that they can, get that person's input, feedback about the process, and then we have a hearing. Now, at that hearing, I can deny the petition if I determine that the person's not in need of a guardian. Or I can make a finding of incapacity and appoint a guardian to represent the person. I can appoint a guardian of the person, a guardian of the property, or a guardian of the person and property. I can appoint a plenary guardian, which means all of the person's rights are assumed by the guardian. Or I can appoint a limited guardian, which means that some of the rights are retained by the ward, other rights are allocated to the guardian, such as the right to marry, to vote, to apply for government benefits, to contract, seek and defend lawsuit, manage property, consent to medical and mental health treatment, to make decisions about the social aspects of a person's life. Once a guardian's appointed, they're required to submit to an FDLE criminal background check. They're also required within 4 months of appointment to undergo training that's been approved by the state of Florida. Every guardian is required to be represented by a licensed Florida attorney. And the guardians are subject to certain reporting requirements, which are going to be probably the major focus of our training here today. Now, once I appoint a guardian, hopefully you're never, ever, ever going to see me again. I'm involved with oversight and enforcement if the reports are not submitted, if the reports are submitted incorrectly. But for the most part, once I appoint a guardian, as long as things are going well, you're never going to see me again. So again, I'm looking forward to the training today. I'm glad that all of you are here, and I'm looking forward to your questions and to learning from the rest of the panel.
Thank you, Judge Spate. So once the court has appointed a guardian, our role as the clerk, our guardianship auditor's role, is to support the court's oversight by promoting transparency, accountability, and sound stewardship. Our guardianship auditor, Lori, currently, does a thoughtful review of the guardianship's reports and asset management practices. They want to ensure compliance with Florida State Statute 744 and to confirm to the best of their ability that the care and resources provided to the award align with the best interest of the ward. This is a collaborative effort that fosters confidence that the guardianships are upholding their legal responsibility to the highest standard. Our auditor verifies accuracy. They check for any discrepancies or unauthorized transactions, and ensure that the guardian is acting within the scope of their duties. Any findings have to be supported in the court in protecting the vulnerable individuals and maintaining that transparency of the guardianship process. On our website, we are doing a facelift of this, just an FYI. So when you go to our website, probably towards the end of August, our tentative date is August 20th. The look might be different, but the information is still going to be the same. So you go to citrusclerk.org, and from there you can go to our internal audit page. And that web page there will give you some additional information as far as our guardianship audits. You can see that it is a link there over to the left-hand side of the page, and that will give you any additional information that you might find beneficial as far as we do have one major change that I think took effect did take effect June 1st. You all should have been aware of as far as the timeline. If anything was missing from your audits, your documents that were submitted for your guardianship reports, that there is more of a timeline now for denying those. Robin probably might speak to this a little bit more in her presentation later. And then we have just some guidelines and resources for guardianship accounting and plans. So that webpage is very useful if you are ever on it and feel that something could be expounded upon, or that some information is missing that we need to be aware of that might be beneficial to other guardians. Please feel free to reach out to us. At the end of this presentation, there'll be some contact information, and you'll also be getting a survey as well that you can provide any additional input on. So with that, I am going to go ahead and turn it over to our Chief Internal Audit Officer who oversees the guardianship audits, Robin Barclay.
Thank you, Tracy. If you would go ahead, Robin, take it to the clerk's webpage. And just so you know, the links are available at the end of this presentation, and we can also send this presentation out to any of you that would like to have it. To have those short links to get to some of the pages that we're going to be referencing today. So from the main page, you're just going to click on Internal Audit. And then you go down to Guardianship Audits. And this is where you're going to find all information relating to guardianships. I'm not going to go through each of the links, but every single form that we offer you, the pre-fillable forms we offer you, and a request that you use can be found from this web page. They are pre-fillable, so you can go right into the forms themselves and enter the information. If you wish to save it, you'll need to save it on your computer. It's a PDF pre-fillable form. You don't have to have the pay version of Adobe Acrobat or whatever PDF writer you use in order to use this form. Some people are under that impression. I know some people that have Apple computers have run into a little bit of issue, but they've obviously been able to resolve it because we haven't had any calls lately about it, and we used to get a lot. If you could go to the calculator. I don't know if everyone is aware, but last year when we continued to see people struggling with the ability to make a determination on when forms were due, I happened to be on someone else's website, another county's website, and I saw they had this really cool calculator built in there. So I went to our amazing IT department and said, hey, can you build this for us? And of course they, excitedly said, yes, be glad to. But we did get this calculator together. It makes your life much easier. You don't have to guess anymore. When is the form due? As long as you know what the letters of guardianship or the GID, the guardianship inception date is, you can get all the dates you need. You would plug in the GID right there at the top. And I can't read it, but I'm assuming it's June something. Hit submit, and then automatically you're provided plan date due dates, accounting due dates, physician exam due dates. It tells you the window of time of when you can submit it. And down the bottom of that, it also gives you some more detail, which this information came from straight from the statutes. So no more guessing on when your due date is. That's probably one of the most common errors we have, which Lori's going to talk about in a few minutes. But this hopefully will take a lot of the pain of trying to figure out when something is due out of the equation. Go ahead and go back to the presentation. So as I said before, all of the guardianship forms that you are required to complete are on that web page. You can click on them. They will take you right to the form. And if you're not sure about which form to use, they're self-explanatory, but you can certainly reach out to us and we'll let you know for sure what it is. The biggest questions come from ETGs, Emergency Temporary Guardianships. And all of these forms have a drop-down, so you can choose whether it's a regular annual accounting or if it's an ETG accounting. So these are universal forms for all the purposes needed. One more. So guardianship statistics. This is the why for today. As of June of this year, we have 444 active cases. We have one auditor. If a person has if a guardianship is over the person and the property, that's ×2 in terms of the work that's sent to her for review and approval. So it's imperative that we help you all ease through the process of providing the information required so that we can get these things reviewed in a timely manner and get it before the judge for his approval. Next slide. So where we stand today, last year, Lori approved 525 different case types, whether it be plans or accountings. That was for the year. We are only at the beginning of July or mid-July, and we're already at 358 this year. So those numbers are expected to, exceed last year's. And again, there's one person who is attempting to get through all of these filings in order for them to satisfy the requirements of the guardianship. So how do we support guardianships? We are obviously proactive in providing resources to you to guide you on the auditing process. We provide general information on the requirements to successfully complete these guardianship reports. We provide information to you on what each report is asking for and how the information needs to be properly documented. We communicate any areas of concern that we have with you as the guardians, with your attorneys, with the judicial system, in an attempt to address the inaccuracies or errors, to avoid any issues with final approval of the documents that have been submitted. I'm sure no one likes to have to resubmit something that's already been submitted and been denied once or twice or 3 times. We want to avoid that as much as possible, but the reality is it does happen. We are statutorily required to review these documents in a time frame, and obviously with the caseload that we have and the one person who's responsible for it, she has to keep it moving. Right now you have 30 cases pending? Files?
Pending to be reviewed?
No, waiting for information.
I believe there's 21 active accountings.
Yeah, she has 21 active accountings right now. That means that once she went through it, she couldn't approve it, and she had to ask for information to come back. So that kind of bottlenecks the process as we have to put these cases to the side and then revisit them. Sometimes it's simple fixes, sometimes it's not so simple. Lastly, we identify any potential threats of waste, fraud, or abuse. Obviously, we're ticking and tying your transactions and making sure that the expenses that the guardians are submitting on behalf of the ward make sense. You know, the person could reasonably have a need for a certain piece of equipment or vehicle, or, you know, take trips, etc. It gets a little gray sometimes with family cases because they go with them everywhere, and they have a tendency to use the guardianship funds to pay for those items. But we have to remember that those monies are for the benefit of the ward. So sometimes we have some struggles with sorting through all of that. And I know Judge Spate does a really good job trying to work through that process with the guardians and their wards. Okay, I think we are, well, we've only been in 30 minutes. Do you guys, are you good? Would you like to take a break, or would you like to wait? We can take a break later. We're moving through it a little bit faster than what we had judged. Okay, good deal. So next I'm going to turn this over to Lori, and she's going to talk about the common errors she sees and the items needed in order to correct them so that you're not having to resubmit over and over again. We want to try and reduce that frustration on your part and make it go smoother for you. So with that, I'm going to turn it over to Miss Lori.
Good morning. Oh. Can you hear me now? Good morning. Okay, so now I'm going to talk about the common errors, and there are universal errors that occur both between the accounting forms and on the plan forms. One of them being submitted after the required due date, and again, you can refer to the calculator that's on the clerk's website. You simply enter the letters that the judge signed, the guardianship inception date. You click submit, and it calculates everything for you. Another thing is that the form is not being submitted on the approved version located on the clerk's website. There are inaccurate guardianship types entered, whether it's plenary, advocacy, minor, limited, and again, that would be on your letters of guardianship. There are inaccurate dates entered for the guardianship inception date, or GID, which again is on the letters. There is an order of incapacity date. If the judge determines that the ward is totally incapacitated or a limited incapacity, you would go according to that date that is on that order. The reporting period dates are often incorrect, and again, you would go to the calculator, submit or enter in the guardianship inception date from the letters of guardianship, click submit, and it's calculated for you. Okay, so once a plan or an accounting is submitted, if there are corrections that are needed, the next version that would be submitted would be the first amended. If it's needed again, it would be the second amended, and they just follow in successive order. I often see on the certification and signature page that the signatures are not provided by the guardian or the attorney, or that the signatures are not dated by the guardian or the attorney. So now I'm going to talk about some common errors that are related specifically to the plans. I believe it's item number 1 is regarding the ward's residency. And a lot of times, all of the information is incomplete or inaccurate. This information is for all residences that the ward has lived during the prior 12 months from the plan period. So if your plan period is, for example, April 1st, 25th through March 31st of 26, all residences that the ward has lived from April 1st of 24 through March 31 of 25 would need to be entered in there. As far as the governmental benefits, there are two categories. It's either eligible or applied. If you're checking eligible, that means that the ward is already receiving this benefit. If you check applied, that means that they are in the process of or awaiting approval for that benefit. With the ward's rights, a lot of times the way that they are answered, they do not match what is assigned to the guardian on the letters of guardianship. And the letters state which rights and duties the guardian is given full power over the ward for. For example, to travel, to determine their residence, to make social decisions, to manage their property, are a few of them. And any right not given to the guardian has not been removed from the ward. If any right has been answered as yes, then you must petition to restore the right. If the physician's report indicates any right can be restored, but you do not agree with that, you can simply provide an explanation on item 9, which is directly below where the rights are listed. For activities of daily living or ADLs, all activities have not been answered or they do not align with the prior plan. For example, for walking or mobility, on the prior plan, if it was answered as cannot do, and now on this one, it's answered as needs no help. I mean, that's a big transition, so we would need an explanation if it is correct, or just verify that it is answered correctly. Or if they do not align with the disabilities or assistive devices identified. For example, if walking mobility has been answered as needs no help, with mobility checked on item 11B as a physical disability, and wheelchair checked on 11C as an assistive device, then that would not coincide with each other. Regarding the physician's reports, a lot of times they are not included or an exam date is outside of the statutory requirements. And again, you can refer to the calculator on the clerk's website, and that will tell you when they should be submitted, which is 90 days prior to the plan period for an adult or 180 days for a minor. All sections of the physician's report need to be completed, and they need to be signed by the physician and dated by the medical physician or medical professional. Regarding DNR or advanced directives, a lot of times this page is incomplete. The DNR, if the first box is checked to indicate that they do not have any DNR or an advanced directive, there's steps directly below this sentence that also need to be checked as verification. Or if they do have advanced directives, we would need all of the information for that. For example, the title of the order, the date that it was executed, the name and contact information of the designated agent or surrogate, whether the court has revoked, modified, or suspended the court order, and if so, the date, county, and state where this occurred. All certifications that apply are a lot of times not answered on the certification and signature page. And also regarding the document delivery information, a lot of times this is incomplete if the ward is not a minor or not totally incapacitated. This section should be filled in. And the information that is required is the ward's name, the address of the delivery of the document, the method used, for example, if it was delivered in person, if it was done by email or postal mail, and the date of the delivery. Lastly, I'm going to talk about some common errors that are specific to the accountings.
I know all of y'all love the accounting forms, don't you? They're so much fun, aren't they? Imagine auditing them over and over again.
So I often see where orders are not approved for large expenditures or transactions for purchases or sales of items. For example, purchases of property, vehicles, boats, for orders approving attorney and professional fees prior to the transaction date or prior to the accounting submission, a lot of times do not exist. The beginning balances are often stated incorrectly, and this must match the ending balance of the approved accounting from the prior submission. A lot of times, I will see like 2 or 3 different amended versions, and when you submit the next annual accounting form, I might see that the beginning balance is stated as the original balance instead of on the amended one. A lot of times the amounts are stated incorrectly for income, disbursement, or cash assets. That there is a lack of incomplete documentation which covers the entire reporting period. As far as like bank statements, we need all pages of the statements. Detailed invoices or receipts submitted. This would be the entire receipt, that it is clearly visible and not altered, or the canceled checks to go with the disbursements. We see mathematical errors if the accounting forms are filled in manually. And again, when they are completed electronically, it automatically calculates everything from each section page and transfers that page to page 1. As far as capital adjustments, a lot of times they are not being reported or that they are figured incorrectly. And again, all of these common errors that I have just gone over can also be found on the clerk's webpage, and it is the link directly below the calculator. So are we wanting to take a break now, or?
Would you guys like to take a break now? It's up to you. It's your time. We're here for you.
She would like to ask a question, but she's more shy than I am.
So, 1 second, I'm sorry. If you don't mind, since you have a question, and if we could just stop right here maybe and just ask some questions from Lori's point or anything that you've heard so far, but could you come to the podium? Since we're recording the session, if you don't mind at least coming to the podium to ask your questions so that it could, whoever's listening to this after the fact can hear the question and answer. I'm sorry.
And if anyone's not comfortable with doing that, just raise your hand and one of us will come out to you and hear your question and then bring it to the podium. There are people that could not attend today and we were not able to create a Zoom or whatever the new technology is, Teams meeting, whatever. We decided to record this and put this on our website for hopefully to help others who have similar questions.
Yes, my question is related to referring to the DNR that's on the annual plan. Specifically, I had a case where we did an annual plan for 1 year. It had to mention it. The previous year, they forgot to mention it, but had gotten a DNR, so 2 years prior. So you've got 3 plans now being presented to the court that were inconsistent. And this was a family member who'd gotten a DNR for the ward. And I just was curious, the court's position with requiring a court order for a DNR when the statute as written refers to the requirement of a professional guardian getting a DNR.
So if you're talking about a ward whose rights have been taken away, somebody has to have the right to obtain a DNR.
Correct. And they
So-
did.
And if they're required to report to the court as to whether or not they've obtained a DNR, and actually in the standard order that we issue to a guardian, it says you can't get a DNR without court approval.
Yeah, so I'm seeing inconsistent orders and letters. Some of the orders say for a family member, it's required to have a court order. And this is, I practice in a variety of counties, so I can't say what the orders would have said for Citrus County, but it's been inconsistent on the orders and letters whether the court requires getting a court order before putting a DNR in place.
Well, statutorily, a guardian cannot get a DNR without court approval. So the court's position would be, if the statute says that a guardian can't get a DNR without court approval, then a guardian can't get a DNR without court approval.
I don't have the particular number on the top of my head, but the statute refers to a professional guardian requiring to get a DNR. And it's left some gray area about the family member.
I'm not familiar with that statute, and, I mean, I'm not familiar with what you're saying off the top of my head, but if the statute requires a guardian to get a DNR, then this court's going to require the guardian to get a DNR.
Sure, okay.
Any other questions? Do you want someone to come to you? Okay.
Good morning. Thank you for this. I was just wondering on the forms, are they not able to update some of these forms with some extra information, such as another page for cash assets, such as anyone that has over $999,000, it won't fit in the spaces on the front page of the form, maybe a space for notes that could be added to save a lot of this back and forth with questions?
We can certainly edit our forms. I know you are special. You have some cases that do have like 11 pages of assets. Most of them don't have that. But you can always add a page. It's just not everyone knows how to add a page to a PDF form before they scan it. But we can certainly look at the number of pages we currently have and add some more. I think adding a notes box is a great idea. I don't know what kind of limitations that'll put on the form itself, but we certainly can look at that and go to our super amazing, wonderful IT team that helped me develop those forms and have them add that to there, because that's a great suggestion.
Yeah, most of the clients have more cash assets than property, and there's 3 pages for property and 1 page
Yeah.
for assets.
Yeah.
And so we have to make spreadsheets or whatever.
Yeah,
So that would be awesome.
we'll definitely take a look at it. Thank you, Mary.
Robin.
Yes.
So I did a quick search of the Florida statutes. I'm not sure if this is what the woman previously was referring to, but Florida statute 744.4431 talks about guardianship power regarding life prolonging procedures. And I'm just going to read exactly what it says in subsection 1. Except as provided in this section, decisions by a professional guardian as defined in Florida statute 744.102 to withhold or withdraw life prolonging procedures from or to execute an order not to resuscitate for a ward must be approved by the court. A professional guardian appointed to act on behalf of the ward's person must petition the court pursuant to the Florida probate rules for authority to consent to withhold or withdraw life prolonging procedures. So that is what it says in the statute, just for you.
So we interpret that to mean it requires a court order for a professional, but how does that stance apply to it being a family member?
Well, that I don't know. So I will repeat the question just for video purposes. So the statute refers to that being a professional guardian But how does that relate in a family member getting a DNR?
So if the person has not previously executed a DNR, if there is no healthcare surrogate that was executed prior to the finding of an incapacity, there is nobody who has got the authority to execute a DNR on behalf of a person. If they've been appointed guardian, and they've got the power to, make the decisions, they can't execute a DNR without a court order.
So the court's position is a court order across the board?
Yes.
Any other questions?
Can you refer to the statute that you mentioned? I got 7444402.
Sure. The 744.4431.
Thank you.
Hello, good morning. I am with a law firm actually out of Orlando, Florida.
Welcome.
And hi. We mainly work in Orange, Osceola, and Ninth Circuit. One thing that we come across is the period between the inventory being filed when someone is appointed and your first accounting. For this county, for Citrus County, how do you all handle if a guardian was to come into finding more assets in between that time period? Do you all require an amended inventory? Is that a requirement here, or are we just waiting for the first annual accounting?
I would start with, it depends. If you've discovered $5 million in assets, you need to amend your initial inventory. If
Okay.
we're talking about, we found money in a box in the closet, or, we found a bank account that had a couple $100s in it, I don't know if the judge cares that it be amended, the initial inventory.
And I think timing is also important. I mean,
Yeah.
I would prefer that the inventory be correct. And if you discover a month or two after you file your initial inventory that your initial inventory is incorrect, you should amend it. If all of a sudden we've got a whole bunch more assets for the first accounting than we did in the initial inventory, there's going to be questions. I think the more prudent practice would be to amend your accounting if you've discovered additional assets.
Okay, thank
Yeah.
you so very much.
And when you're amending it, you need to make sure you're detailing that these assets were discovered. I know does the initial inventory have a capital gains and losses on it? I can't remember.
Not on the initial
I don't think it is.
inventory.
I think it's
No,
only
it's
on the
just on the
annual accounting. If you're towards closer to the annual accounting, you wait till the annual accounting, because we get them like that often. They'll make the adjustments on the capital gains and loss. They just put an explanation underneath it so that we understand that it's assets that were discovered after the initial inventory.
Wonderful, thank you.
Is there a form for family members to fill out online for emergency temporary guardianship?
Well, we only handle the auditing side of the world. We don't handle the probate guardian. Sonia, can you answer that?
Oops. I'm kind of new here. Those forms are not available for emergency temporary guardianship, and also, generally speaking, for that sort of guardianship, you would probably need to be represented by an attorney, and we're not attorneys, so we can't put out forms that attorneys would generate.
Okay, so you have to get an attorney?
Yes.
Okay, thank you.
Great questions.
I have one question. On the accounting, we have an accounting right now that has not been approved. We are to the point where we need to file the next accounting. Do we use the balance that we have from the original accounting? And if it's wrong, then update the next year's accounting?
So just so I understand, you have a current accounting that has not been approved,
Yes, ma'am.
and you're now looking to do a final accounting,
No, we're doing the next year's accounting.
the next year's accounting. Well, until that current accounting that has not been approved has been approved, you can't proceed to another accounting. We will not even review a next year's accounting if the prior year has not been approved yet, because that drives the ending balances of that accounting drive your next year's accounting. So you want to make sure you have the numbers right to start with. Otherwise, you're starting that same process all over again. You're starting off potentially wrong, and it's going to end up going back and forth until we get it right. So that prior year that you're working on still needs to get all the way through and approved.
So then we needed to notify the clerk that it has not been approved so that we're not we're not in trouble for not filing the next year's accounting on time.
Well, I can't answer on the legalities of that. I'll let the judge speak on that, but we can't look at another accounting when we know we don't have a current accounting that is accurate. So
You're going to get an order requiring each year as it becomes due, but the prior years will not get approved. Your 23, 24 has to be approved before your 24, 25 will be approved.
Okay. All right, thank you.
yeah. But if you're struggling, we're here to help. So we want to help you get through over the finish line.
Good morning.
Good morning.
Would you please comment on the guardian being the petitioner if no one else is willing to step up and do that?
Meaning you don't have legal representation?
No. How do you feel about the guardian petitioning for being the petitioner for the guardianship if no one else is willing to step up? If there's no family member, if there's no one at the facility that's willing to come and ask for the guardianship?
I'm not quite understanding.
So you said the guardian would be petitioning for a guardianship. There would be no guardian if there were no guardianship.
I mean, if someone that was a guardian, that has not been appointed the guardian.
Okay.
But the guardian is aware of a situation and no one else is willing to step and ask for the...
Statutorily, any competent adult can petition for the guardian. We get it, most of the time it's family or it's, the facility where the person's staying. But we've had the next door neighbor who's known the person for, 30 years who is identified that there's a problem.
Right.
Anybody can petition.
Okay, so no conflict of interest if that person is going to be the guardian, proposed guardian. If somebody is going to be, I'm a professional guardian.
So yes, you can petition.
Okay.
For a guardianship.
Okay.
That's why we, sir.
Change that. I represented Rebecca Furley, and what used to happen is the hospital would contact her, she would file the petition, get appointed, and then she would be appointed to guardian. But because of that whole circumstance, I guess, raising people's hackles, they changed the statute so a professional cannot apply, be a guardian himself or herself. It has to be done by some other individual now.
In any circumstance?
I wasn't aware of that. What's
we
the
need-
stat?
Off the top of my head, I don't know, 7.4 point whatever, but they changed that as a result of the whole Rebecca Furley situation.
We need you to be by the mic if you don't mind. That way it's recorded and other people can hear what you're saying. I'm sorry. Didn't mean to overstep.
Harry Hackney, Tavares, Florida. It's my understanding that the statute was changed a number of years ago, and a professional guardian cannot apply to be a guardian for themselves any longer. It used to be they were contacted by nursing homes, assisted living facilities, in some cases hospitals, because they would have an individual who had no family or relatives and they would need a guardian. The nursing homes, ALFs, and hospitals knew who the professional guardians were, and they would contact the professional guardian who would file their own petition to be appointed guardian.
But they're required to be represented by an attorney, so an attorney would need to file it. They can't file it.
The attorney would be filing it, yes, but they would be the petitioner. And statutorily, they changed that after the Rebecca Furley case because the hospitals were getting her to petition because they had individuals that they could not safely discharge. And so somebody had to petition to be the guardian. And in those circumstances, there would be no family member, neighbors, et cetera, available. So it's my understanding that now, and I can't look it up in here because I don't have a Wi-Fi connection, but now the statute requires professional to be, not only be represented attorney, but for somebody other than the professional petition for the guardianship, which is, I think, is what the lady is referring to.
Okay, so if the statute says you can't, you can't.
So just for reference, that statute is 744.334, petition for appointment of guardian or professional guardian. And it looks like it is subsection 2, that if the petitioner is a professional guardian, she or he may not petition for his or her own appointment unless the petitioner is a relative.
And that was the nuance I was going to point out. There is a little bit there. So a professional guardian cannot petition to have themselves appointed. But also, just because you're a professional guardian doesn't mean you cannot seek the appointment over your family member. So that's just a clarification I wanted to make.
Thank you.
Awesome. See, we're learning too. I like this.
It's great information.
It is. It is. It's great questions too. Anyone else have more questions?
And it's back to the DNRs. So I went before you for a DNR, and you gave the DNR, and she died a few days later. But like, I have like a case with a lady that lives in a nursing home. She will take some medications.
I'm not going to pre-decide a case that you're not filing a petition on.
Okay, no, I meant how easy, I mean, do you have like certain criteria that you're looking for to?
Yes, and they're in the statute. And
Okay.
I'm not going to pre-decide a case that you're just asking me about here.
Okay.
I'm curious, how many are current professional guardians? Wow, I'm surprised. I didn't think we had that many in our area. How many are family guardians? How many are interested in becoming a guardian? Nice. Okay. Any other questions? Those are my questions. So if everybody's good, I mean, we can take a break. Again, there's water, there's some sweet treats over there if you're interested. If not, we can keep pushing through. This is your time, so don't hesitate to ask more questions, and I greatly appreciate it. This has been something we've been wanting to do for about 5 years, to all come together like this and talk about guardianship. So I'm excited that we're able to do it. I'm a little disappointed we're doing it on the end of her tenure, but we're really excited about having this opportunity to have interchange and discuss, this wonderful world we all appear to be working and living in. So things are changing. We've been working very hard to refine our process and to make it more efficient, both for y'all as well as for my team, because again, with, over 500 cases being audited in a year by one person, that's a lot, So given that, we've got roughly 200 real days to actually make that happen. Some of these accountings take 3, 4, 5 days just to get through, much less come up with any discrepancies and then communicate back and forth with the guardians, and then get responses back or, amended filings submitted. Then they, again, get reviewed again. And if there still continues to be discrepancies or more discrepancies are uncovered, then it's the back and forth a lot on some of these cases. And so our goal is to try and reduce that as much as possible, and be a little bit more clear with, what we're doing, how we do it, and what we need from you. And then hopefully with, having come together, we'll come ahead on this game. And of course, none of the repeat offenders, if you will, none of them are present today. They didn't come. So it's not any of you. So we're not talking about anyone here. You all do amazing jobs. Submit your documents timely, complete. with all supporting documentations, and we don't have to do anything but stamp approved on them. So let's be clear about that. But contrary to popular belief, auditors cannot be a substitute for the guardian's accountants or bookkeepers. It is not in our wheelhouse to be that person. However, those people that aren't here often expect us to be their accountants. And they basically throw their information in a form to us, none of y'all, and submit it to us and wait for us to give them a detailed response as to what's wrong, what page, what number, what item, how to fix it, what do you need to supply in order to support that. Those happen more often than not. It is extremely time consuming, obviously, when we have to decipher the information that's been provided and then determine that we don't have the receipts to support it, or we can't read the receipts. We recently had an accounting submitted that not a single receipt is legible. I mean, it's like they must have e-filed it, and it did not, when it scanned, it didn't capture the ink of the receipts. So none of the receipts are helpful to us. Also, auditors are not attorneys, so we can't give legal advice. And we're often asked for legal advice. And we have to walk very carefully on that line to try and be supportive of you, but not appear to be difficult with you because we can't give you the answers you're looking for. So when we tell you that you need to ask your attorney, it's twofold. It's one, you need to ask your attorney because they're the experts. And two, we're not. So our information could be completely wrong. And so keep that in mind that while we might know the answer, we can't give the answer because we don't have a law degree. Another big change is the email. How many of you guys email us? About half of you. So imagine that times 10 on a daily basis. That's how much volume of email that Lori deals with day in and day out, in addition to working on the cases. So we are going to change the way we're handling communications. The email that you're going to begin receiving from us is going to be a, what do you call it? Do not reply type email. We're going to submit to you the documentation request information letter, and it's going to be actually docketed to the case. So now the judge will actually see the information we're communicating with between the guardian and ourselves. In the past, none of that information was docketed. So, you know, we would have 5, 6, 7, 8 emails back and forth, back and forth, back and forth with the guardians, and the courts would not even be aware that all this communication is going on. All they would see is the end result when we would submit the recommendation for approval or denial. So now we've actually got a form that we've created. It's a template. And as Lori conducts the audit, she's going to complete that form. Go ahead and pop over to that. I'll come back to that in a minute. I don't know if you guys can see that, if you've got magnifying glasses with you. But I'll be glad to share again this presentation with anyone. So, you know, if you want to see it up close and personal. So basically, it's going to look like all of our other court letters, correspondence that the clerk's office sends. It's going to be coming from the clerk of courts. It's going to identify, based upon whatever you submitted us, it's going to identify the page number where there is a problem. And it's going to give you a general understanding of what the problem is. And again, like I said before, if it's an accounting, we've taken ourselves out of the role of being the bookkeeper or accountant. So you'll have to go to the page and see what we've identified and then determine how to correct it. Now, that's not to say we're not going to be willing to discuss it with you, you can pick up the phone and give us a ring. If we're available, we'll take the call and walk you through it. If we're not, we promise the sundown rule of communicating back to you before the end of the business day. But this hopefully will allow the auditors to focus on each case she's working on, so that we're not having to pick them up and put them down, pick them up and put them down throughout the day. But that form will go out for both plans and accountings. If there's a deficiency, you'll get a letter. It'll be docketed. It will be emailed to you unless you indicate that you need, what do you call it, snail mail, the old-fashioned postage stamp mail. And it's going to go to you, and you're going to have 2 weeks in which to respond. Not everything can be resolved in 2 weeks, and we understand that, but the majority of things can be resolved in 2 weeks. If you need more time, then you're going to have to make us aware of that, and it's going to have to be formal. We have some cases, on an accounting, we have up to 90 days to make a recommendation, and sometimes we're 6 months, and we still haven't gotten resolution on a case. And that's the kind of stuff we're trying to tighten up on and do better. Now again, that email address is going to be coming from Guardianship at citrusclerk.org. It's going to state on there, do not reply, because it is an unmonitored mailbox, meaning it will go to Never Never Land and we'll never see it. I know some of you guys have our email addresses already, and that's fine. You can still communicate with us that way. Just know that this is how we're going to be communicating going forward. Unless, again, we've already had discussions and we're in the works. It's starting today. It's starting today. The 2 weeks started June 1st, and that was announced on our webpage. And I sent in my original email when I let you guys know we were having this wonderful workshop, that was happening, so that you would kind of be prepared that there was something coming around the corner. So once we're done, I'm curious, how many of you have go on the docket and look at the docket? How many of you can actually see the documents? Because I discovered this week by accident by another attorney that if you have not created a scores, if you've not registered with scores, that's why you cannot click on a document and open it. But if you're a party to the case, you have the right to open those documents. So if you haven't done so, you might want to go in and follow the instructions on our website. How many people have a scores account? So only a handful of you. It's going to be important for you to be able to go in and see these documents. So I would strongly encourage you to make that one of your first things to do.
Does anybody not know what scores is? Okay. So scores, again, was built by our amazing IT department. And it is a way for you register. And if you're a party to the case, you can view those documents. And it is a way to look at court records. So some court records, like probate cases, are protected. There's an actual matrix that comes from the state that tells us who can have access to what case type. So scores is just what we call our internal viewer for court records.
I have the application and it's filled out and it's notarized. Who do I turn it into?
So her question is, just for video, that she has the application for scores filled out and notarized and wants to know who to return that to. You can give it to any of our girls at the front counter. Actually, if you don't want to stop by there, you can give it to Natasha over here. She's got her hand raised in the corner. But if you do fill out the application, you can always turn it to any of our girls at the front counter. Or gentlemen, I'm sorry. Our deputy clerks at the front counter.
And SCORES stands for Secured Courts Online Record Search System. Thus, SCORES. I saw another hand, another question. You want to come up front?
No, you got to come to the podium.
We can't hear you, I'm sorry.
I'm assuming the application for the scores is on the website?
Yes.
Okay.
Yeah, if you click on, I'm on a PDF. You click on record search, and there's a section in there that talks about scores. But if you need help, just pick up the phone, call us. We'll be glad to help you.
Okay, thank you.
So the good thing is if you do complete the scores online, you can submit it electronically as well. You don't have to always print it and bring it in.
Thought I saw another hand. Was there another question? No? Okay. So going back to our process, so we're going to be going back, and again, this is for those people that are not present, that are not here, but those repeat offenders every year, over year, over year, over year, submit the same mistakes over and over again. We have tightened the belt on those people that are not present and said that in 2 weeks, if they have not corrected their documents, and we'll send out a letter notifying them of, that request, what they need to, we are going to submit a recommendation for denial and get it off our stack of 21 cases pending, because that's what all of those are sitting there for, waiting on something. Half of them are probably stuff that we've been waiting for every year, year over year over year, same mistakes. So we're hopefully going to redirect those people so that they start submitting it right the first time around, because it's a lot easier to get it done up front than it is to have to go back and do a first amended, second amended, third amended, fourth amended. So, but once everything's said and done and we can happily submit that recommendation for approval, there's going to be a template that we're going to be submitting. It's not going to look like the current worksheet. If any of you have seen the worksheets, I know Kathy Rector's here. She knows what I'm talking about. She's the final sign behind us before it goes before the judge for their sign on the orders. We're going to have a recommendation for approval or denial. And if it's a denial, it will list the specifics as to why that particular case could not support a recommendation for approval. And then the last and final voice always is our judge. So Judge Spate will review what we've submitted and either sign the order for whatever we've recommended, or he might say, no, I don't feel that's necessary to deny, and he can override us and approve it. But at least in this manner, it's clear and concise to you guys exactly where our mindset is, and under our professional opinion of what's been submitted, either adheres to the statutes or doesn't. So, if you need additional time, though, put it in writing, send it to us, and notify us. Judge, do you require that they petition for additional time?
Yeah, and that's routinely granted.
Yeah.
Yeah, if you give a good reason why you need more time, we'll routinely grant that request.
Any other questions? Good morning.
I have a question about the form that is used to put all of our entries in, our expenses, et cetera. If we find another receipt and we want to insert it, we can't just create an insert line and put it in there. It has to be typed all the way all over again.
Stick it at the bottom of the list.
It doesn't have to be in the order?
I mean, we would, obviously, it would be easier to do it that way, but
Okay.
but please don't recreate your form to get it in sequential order.
That's exactly what our paralegal has been doing. So I just wanted to clarify that. Thank you so much.
They could put, because those are, correct me if I'm wrong, but those are free form information. So like in the description line, you could say additional receipts found above it, and then put it, the dollar figure that goes in that far right column is still going to run tally and go forward to the first page, to the summary page.
Perfect. Thank you.
Yes. Work smarter, not harder, right?
Yeah, exactly. I have a couple of things, and I was waiting to see if any of it got addressed before I asked. We keep a running Excel spreadsheet of each transaction as I go. So when it's time to make the report, it's already there, it's in order. There's no way I can copy and just transfer that over. It has to be entered in manually. I didn't know if there's a way to change it so that I could just copy paste and save that time.
I'm not aware of a way to copy and paste it from a Excel to a PDF, but I'm sure if there's a way, I can bounce that off our IT to find out if there's a way to do an import. Robert,
Because I can
you?
change from Excel to PDF, but not from,
Exactly.
yeah.
Are you aware of any idea?
Okay.
Rob, while he might be my senior auditor, he's also my personal IT guru.
No.
And he runs tests for me all the time on stuff. I'll say, why can't we do it this way? And he'll say, I don't know, let me go see. So we'll definitely give it our best effort, because I agree. And, you know, and people sometimes use financial software too. You know, I think, Mary, do you use? Yeah. So
Being able to
if there was a way to
move it
import
over.
it, we would certainly, you know, support it if we can. And I'm speaking for the clerk, but, right?
Absolutely.
I'm not able to import it either, but I use those checkbook registers and attachment, and I do a summary on an expense page by category.
Yeah.
So that the numbers get onto the first page.
Yeah.
It's the Quicken checkbook registers.
Yeah. Because that's the bottom line. We just want to, you know, if you guys aren't aware, those forms that we have that are pre-fillable, they do all the accounting for you. So they take the error, hopefully.
As long as you're entering in the right numbers.
Exactly. We take that out of the equation, and it should help your front page balance.
Yeah, what I've done, because I've had the same issue, is there's not enough room and you can't add pages, is I type it in, print it out, erase it, type in, and then I make a summary of all the additional pages so the numbers work out correctly when they get moved.
Yeah.
Yeah.
What some of our people do, and I know you have, the very last line of like all the disbursement or all the income, especially on income, if you got a lump of income, is you do a one-liner on the bottom and say from extra page, blah, 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 and put the total dollar amount, and then it runs up into the
Right.
totals for the summary page.
Yeah, and then I just add the extra pages. Then the other thing too is I run into a lot of times, I have my accounting, submit it's done, and they say, I get a request back that says for information that's not in the date range. And I have to say, it doesn't apply to this accounting because it's to a different date range, and that's why it's not included on my report. So.
You're getting a request from us
Yes.
asking for information outside of the reporting period?
Yes, because it's, oh, you had set up for an ABLE account, but we don't see it on this because it wasn't actually set up yet. So that's why you don't see anything. It was moved at this time, so it will be on this reporting period because I got the approval, but it didn't get set up in the time period, as an example. The
Okay.
other thing too, as was brought up earlier, is my accounting's in, it's balanced, but you're only one person, so you haven't approved the prior accounting yet. I know that it's great and there's nothing wrong with it. I can't submit the next one even though it's due. I haven't gotten a, hey, you need to change anything. I just haven't gotten any kind of response at all.
Was the original accounting submitted timely?
Yes, my reports are usually prepared within, I'd say 3 weeks I'm submitting for accountings.
But what you're implying, and I just want to make sure I understand you, you're implying that the prior year has not been approved and you're already submitting for a new year.
Yeah, I'm prepared. I have all of my documents. Everything's ready. It's balanced. I'm waiting a response that either says we recommend approve or not approve, and I've gotten 0 response in a year. So I've called, and then when I call and I say, hey, it's time for my next one, they go, okay, we'll move it right on up. And then in a week, it's like, okay, we recommend approve. So I'm like, okay, here's the recommend approve. And then I'm immediately submitting my next report because I already have it ready.
This is with another accounting you're talking about? Okay, because I'm like, I know we don't have any
No,
like
no,
that
this is
because I
different.
have a rock star over here.
Yeah, no, this is different, but that's what I'm saying.
Okay.
Is, so in
Ugh.
the instance of, because of a backlog, what do you recommend gets done? Because I'm like.
So that doesn't happen in our county. You
Yeah.
want to talk to the other?
It doesn't happen often. It's happened.
You clearly
once
need to be over in this county.
It has happened once to me in this county.
Yeah.
But yes.
But no, our clerk staff is excellent and are not going to have a year backlog if you're
Okay.
submitting the proper accounting.
Yeah.
Yes. Yeah,
If-
because I submit accountings within 3 weeks of the beginning date that you can.
This clerk's office is on top of things, and we're not going to have a backlog if you're submitting yours properly.
Okay, and then last question I have, with this new do not reply email thing, if we have to submit a reply because it's an answer to a question and not necessarily a correction to be made, are we going to be able to reply directly, or are we going to have to spend Ward's money to have an attorney to file a response for us?
No, yes, yes and no. It depends on what the responses are, whether the attorney, I mean, our experience in our county, and I'm only speaking for our local attorneys here, they want everything to go through them.
Yeah.
So, if there is a response to something that is questionable in transaction,
Like, for example,
needs
the
to be on
reason
record.
it's not on there is because it doesn't apply to this accounting period.
if it's ancillary or truly not material to the case itself, then we're going to communicate via phone and probably you'll email it to our auditor.
All right, so if it's something that's simple like that, I
Yeah.
can just call. and
If
then it
it's
can
something
get
material,
addressed.
then you're going to need to go on record, and so it does need to be docketed.
Okay, all right.
You know, we're trying to be more transparent in our communication and the activities of the cases. And a
Right.
lot of that activity is not transparent when it's only through via emails through the auditor and the guardians.
Yeah, no, and I appreciate that. It's just paying an attorney to reply to a question is a lot more expensive for my ward than me just replying and saying, hey, it's not in that accounting period, you'll see it on the next one.
Sure.
And so that's the only reason I'm like, if it's
Yeah.
something small like that, I think it would be.
Yeah. I think most everyone has our email addresses. You know, I'm not telling you, you cannot email us. That's not what I'm
Right,
saying.
I'm just saying if it's on the docket, I don't want to
Yeah.
show that I'm not responding in some way that it looks like, you know, I'm not doing my job. So like right now, it doesn't look like either of us are doing anything, even though we are. But now this new way, you guys are going to do something, but I can't respond without my attorney. So it looks like I'm not doing my job for my ward
Yeah.
on the docket if somebody's reading it that way.
All you have to do is pick up the phone.
Okay,
That's all.
all right, thank you.
Good morning. I have a brief question regarding inventories. We have a specific case where we submitted an inventory. There was an annuity listed, which the ward did not have access to because it's an inventory. He requested information, but he had not gotten clearance. So he didn't have any supporting documents.
You mean the guardian?
Yes,
Okay.
sorry. Guardian did not have any documentation to provide supporting documents. So we just recently received a recommendation or an audit report stating that they needed that information. So I don't know how the court wants that handled. Should we obtain
So
an
we're not going to
extension?
answer specific questions about specific cases in this
Okay.
forum. If you have something you want to put in front of the court, file a petition.
I'm just asking a general question.
No, you're asking a specific
okay.
question. So
Okay.
we're not going to answer specific questions about specific cases in this forum.
Okay. Can that be rewarded in a different way? As in, if we don't have enough documents, should we obtain an extension or just,
If you've got a reason to request an extension, petition the court for an extension.
Okay, perfect. Thank you.
Can I just go back 1 second to the previous lady that talked about the fact that we're going to send them an email and that's going to go on the docket, but their response doesn't necessarily go on there. Robin, I know will provide, and I think at the end of this presentation, it does have contact information as well. So if you want to pick up the phone or if you want to email our auditor directly. But as a sidebar, Robin and I will talk about that later, just so that you all are aware. If we make any changes with that, we'll be sure that we communicate those changes out to you all. Because I do have a couple ideas and thoughts in relation to that. But just rest assured that you will have the phone number and the email of our auditor to respond to that email that you might get from our do not respond email right now.
And we're getting close on time, so I'm going to have Sonia speak up on something that came down through legislation this year. I think it was legislation on the data transparency database for professional guardians.
Yes, I'm going to tell you, or we're going to discuss the Florida Guardianship Database Transparency System, FLGDT, and that's all a really tongue twister, so I'm going to call it the Transparency Database. And it started actually with a guardianship task force sponsored by the Florida Court Clerks and Comptrollers. And they took it all the way to the legislature, and it ended up implementing a new law, implementing this comprehensive database of transparency of professional guardians. This provides the court to make a informed judgment when they appoint a professional guardian. Before, there was no way for anybody to see where are these people, where are these guardians' wards? And this is specific to professional guardians. So the law went live on April 1st, 2024, and it was actually fully implemented earlier this year because there was a lot of stats that had to go into this database. This is a statewide database that the courts can go into and look up a lot of information on there. It contains the registration status of a professional guardian. The professional guardians that are all here know you have to be registered with the OPPG, the Office of Public and Professional Guardians, and you have to have an active registration. That's something that now the judges can pull up and they can see this. They can see any professional guardian anywhere in the state. They have demographic information, the location of the guardian's office. They can search it by the ward's name, by the guardian. They can see which cases they have over in which circuit in Florida and who the presiding judges are, which circuit, which county. They can, as I said, they can see the status of their, whether they're active or inactive, when their expiration date is, any substantiated disciplinary history for these professional guardians. They can see their status of their compliance with submitting timely reports. As you all know, they will submit initial plans and annual plans, initial, annual, final accountings. The judges can now see if they're in compliance with submitting this. So this is just specific to the courts because it contains a lot of personal information. So what about the public? What can the public see? Well, actually, on the OPPG website, which is with the Department of Elder Affairs, also the Office of Public and Professional Guardians, there's actually the OPPG website where the public, me, you, anybody in here can go to that website and access information on the registered professional guardians also. And what that contains a lot of useful information. What can we see? We can see the address also, just as the court can see. We can see their registration status, the same as the court can see. Active, inactive. We can see their registration expiration date. How long is, their license good for? We can see if they've met their education and bonding requirements, same as the court. So you're getting a lot of information on the public access site too. We can see that the bond's been issued to them, just like the court can see. We can see the counties they're served. We're not going to see specific ward information for them like the courts can see, but we can see all the counties. We can see that they're in Citrus, in Marion, in Lake, in Alachua. We can see all the counties that they serve in. And again, we don't see the personal information, which is why the public doesn't have access to the court system. There's too much personal information, which can be detrimental for the wards because they are very vulnerable adults. You know, they've been declared incapacitated, a lot of them, and even the ones that haven't, even the advocates, they're vulnerable, you know, they're some of our most vulnerable population. So that you can't see. However, you can see even substantiated complaints on the public website, just like the courts can see. There's also, if something has been substantiated, there's a link to the final order from the Department of Elder Affairs, you know, the OPPG. So yes, if you've had some disciplinary history where an order has actually come down, and this is just for professional guardians, everybody can see it. So just go right in there, and there will be a link to it. So that's important. This is, you know, part of the transparency with our professional guardians. So now the Florida Clerk of Courts, as I said, it was the clerks and comptrollers that actually began the task force, which eventually led to this legislation and this, you know, law being implemented for transparency. The Florida clerks input a lot of information into the system. It's the Clerk of Courts providing all the monthly statistical data on compliance. As a matter of fact, well, I'm a deputy clerk, me, Edith, Maggie. We go in every single day if there's non-compliance with, we check every single day. We have to go into this. This was a huge undertaking between our business analyst and our IT department. Citrus County was actually in the work group that assisted in implementing this, because it is the courts, it is the clerks of courts across the state that have implemented this. And again, Citrus County, we were in that work group. Me, Edith, Maggie, Robin, we were all there. Natasha, our managers, we were all there. And it was business, all of our business analysts. It was huge, complex, extensive. But this is now available to the whole state. As I've said, it's available to the court system. It's available to all of us. Anybody can go in there. And again, though, the public access ward information is limited because there it's private. We can't have that info out there for everyone. So it is the clerks who built this database. And it is the monthly stats that go in there. You know, the clerk has to get it right, and we use every effort to get it right. The courts are relying on the clerk, the public is relying on the clerk. And as I said, we go in with monthly reports that the stats go into there, we go in daily reports. So the court system will see all that, compliance and not compliance. Now, all of that compliance and not compliance with the, you know, the reports, that is not in the public forum database, but the professional guardians and the clerks, you can go in yourself and you can see on your docket if you've been in compliance or not in compliance. So when those reports have to be submitted timely, you really need to get them in there, because if the court has to send out an order requiring, you're gonna get dinged with a non-compliance. That being said, every time you get your reports in, you get a star, compliance, compliance, compliance. So the judges are gonna see this. So you wanna get those reports in, and if you ever have any questions about, oh my gosh, when it's due, remember that calculator. Because when people would call, we can even usually answer that question. If we're not sure, you know, we will check with our auditing department. They're fabulous. I cannot believe Lori is leaving us. Not sure who made that decision, but there you go. So anyway, so yeah, get those reports in, because yeah, it's all going to show up now. And if you want to say, well, have I not been, look on the docket, you can see compliant or non-compliant. Now this is just for professional guardians. So actually, to summarize these key components of this transparency database, one, transparency. That was the key component. The information is publicly accessible. data collection, the registration status for the professional guardians, the compliance with qualifications to be a professional guardian, the required reports, timely filed, and searchability. There's various criteria that court can search it. They can search by the ward's name, their legal counsel, their guardian, their demographic information. So this guardianship database is a vital tool for the Florida courts and for the public, which was implemented actually after serious calls for reform when some bad actors, bad guardians, had allegations against them of abuse, neglect, and exploitation of funds of the wards. So Florida needed something, we all needed something. So this transparency database, it is complex, but it brings much needed scrutiny to the complex guardianship system. And I'm also reading, it is the first in the nation to do this. Florida's the first in the nation to do this. Thank you, clerks and courts and comptrollers. And so I'm sure other states are going to look to Florida as a model for guardianship oversight. Thank you.
Thank you, Sonia. And to back that up, I just wanted to you're on the right page. Go back. There is on our website an area for reporting concerns on guardianship cases. It's labeled guardianship fraud reporting, but it could be waste, abuse, whatever. This form is available to any citizen anywhere if they have a concern over a guardianship, over a neighbor they know has a guardian, over a professional guardian who has concerns over another professional guardian. You can file a report with our office, and if you elect to, you can remain confidential. But this information, we ask that if you're going to remain confidential, that you provide enough information, because if you don't provide enough information, we aren't going to get too far with it. Last year, kind of backing up what Sonia was talking about, after that work group came together, that was a runoff from the previous group that we had, which was the SIA, the Statewide Investigation Alliance, that was formed, I want to say about 2 years ago, maybe 3 years ago, Tracy? Maybe 3 years ago.
It was 3 to 4 years
Yeah,
ago,
because it spun off the task force that actually ended up working on this transparency piece. But because of some major bad actors in the state of Florida on some really, really horrific cases, they formed the SIA to conduct investigations of potential fraud, waste, or abuse of wards. And it was headed off by several different Office of Inspector General offices within the clerk's office. They're basically the same as us, except they're IGs versus just internal audit. So they have some legal privileges and powers that we don't have as an internal audit shop. But anyway, there were 4 different counties that were named as these SIAs. And so if I had a case I was concerned about that was beyond our ability to research and investigate, or I needed their authorities that they had for subpoena and other things, we would refer the case over to those different counties, and they would conduct an investigation, make recommendations to law enforcement or to their local jurisdiction, their court system. So they have disbanded. That happened about a year ago. OPPG, Department of Elder Affairs, they took over some of the authorities that the SIA had, and the SIA felt that it was overstepping their already previously given authorities, so they disbanded the SIA. I'm hearing from different other clerks' offices that they're going to be coming back, but I haven't got any details as to when or how or what that's going to look like. But just want to make sure you guys were aware that there is an avenue for you to make a report to us. We take that information and we will likely turn it over to an IG office that has the authorities to do the proper investigation and subpoena of records and stuff that they may need to investigate. They will physically go on someone's doorstep, knock on the door, and ask questions and demand information. So we've already been through questions and answers, but is there any more questions? I see one.
Hi, I have no DNR cases in this court anywhere right now. I just have a question that, what would you like to see as evidence that a DNR is appropriate? Is a letter from a doctor okay? Do you have to have the doctor there?
It's in statute. I mean, I need an affidavit from the doctor. I prefer to have the testimony from the doctor. What you need to have in the petition for a DNR is set out in the statute.
Okay, I'll look at it again. We have a lot of trouble getting doctors to be willing to come to court. It's really difficult sometimes, and hospitals are like, oh no, we don't want any part of that, you know. And I try to explain to them, look, it's a formality. You need to go. You need to say why it would be a good idea for a DNR.
I can have an affidavit that sets out the specific criteria.
Okay.
For a DNR. Refer to the statute, what I need to do a DNR.
Okay.
And that affidavit can provide the testimony from the physician.
All right, thank you.
Great question.
I'm the parent of a disabled child, and as I get older, do I have to, to have my child, other children become a guardian? We're gonna have to apply for a whole new guardianship, or can we do it? Do you do a transfer? How does that work?
There is a process for appointing a successor guardian.
Okay.
Yeah, if it's your other adult children who you want to step in as the successor guardian, just have them submit a petition.
Okay, and is there a form for that on the, I've never seen any, that's
I
why.
don't, I don't believe so, but a guardian's required to be represented by an attorney, so talk to your lawyer.
It's an advocacy.
Oh, it's a GA.
Yeah. Sorry, yeah, I'm disabled. You said that earlier about having to be represented by a lawyer, my heart went, I do what? I do not?
No.
Advocacies don't.
Advocacy.
No, it's a GA now. You don't have to be represented by an attorney. Okay. But I don't believe we have legal forms on the website because that's basically the equivalent of giving legal advice. But if you want to have somebody else just
we have to get a lawyer, we just have to figure it out.
Google is your friend.
Submit something to the court asking for the appointment of a successor guardian.
Thank you.
Great question. Any other questions?
I have one quick question. With the new process for filing the orders, do you prefer that on plans and accountings, we wait until it's approved to file the order or file them all at the same time?
I'm not sure what you mean. You mean if we've identified a deficiency in an order?
No, when you file the plan in the accounting.
The unexecuted order.
The unexecuted order, does that get filed at the same time or after it's been approved?
They typically file at the same time, don't they?
Yes, they've always filed it at the same time.
Okay.
Yeah.
Just a question. Thank you.
Those orders are typically filed at the same time that the order approving is submitted at the same time.
We generally run reports, and once we see that all the recommendations have been made by our auditors and by court administration, then they'll be set for judicial review.
Yeah. So give you the link to, I'll give you the link, show you the links that we've put together. If you could go back to the, there you go. Here are some helpful links for you for Office of Public and Professional Guardianship, the OPPG. This is where you go to get all answers to questions relative to becoming a professional guardian. You also have the Florida State Guardianship Association. I don't know if any of you are members of the association. Anybody? I know their conference is like next week, maybe? Following week? Yeah. Also, Elder Affairs, there's a link for that as well. All of these different organizations, governmental entities have a lot of information for you about guardianships, about becoming a guardian, et cetera. Next page.
All right. So this concludes our first guardianship audit forum. So coming soon, we are going to have anywhere from, we're going to have some instructional videos. They'll be anywhere from 3 to 5 minutes. It's going to include how to complete various guardianship forms, and that is all going to be posted on the Citrus County Clerk of the Circuit Court's website and probably our YouTube channel. Yes. We will have, you will get a certificate of completion for the 2-hour workshop for all of those who request one. We're not going to send it out to everyone, but if you request one from us, you will get it. Keep in mind that the workshop has not been pre-approved by the Florida Bar or the Department of Elder Affairs. So you'll need to determine whether or not the workshop can be counted towards your CPEs. If you did not sign in on the sign-up sheet, be sure you do that. Where is it located at, Sheila?
As you go out the door.
Out front, as you go out the door, be sure you sign that if you, so that we can have your attendance, and I believe it has your email address on it, because we will be circulating this presentation. This presentation that was recorded today will also be able to be found on our YouTube channel as well. And there is a, when you do get this presentation in your email, there is a survey. We can only improve these workshops with your feedback. So if you find that there was some information missing, something you didn't get, or you don't, even if you just want to say great job and kudos for the first one, please fill out that survey. Also, I think that's it. I want to thank the panel and thank you specifically to Robin Barclay. She was the one that headed this up and got the right players to the table. I want to thank Judge Spate for his time today, to our Sheriff's Office for having a bailiff present for this presentation, the probate staff, the internal audit staff, and Natasha and Heather for being present, as well as Kathy Rector. Beth, thank you for being here. I failed to mention, and so my conscience won't let me if I don't. Maggie Mothershed is also part of our probate division. Unfortunately, I think she has left. She has just given birth to our new Clerk family edition, so she is out right now. But she did come for the first part of our presentation, and I apologize I did not acknowledge her up front. So with that, congratulations, Lori, on your retirement.
Yes.
And anyone who has worked with Lori or would like to wish her well, we are going to end today's session with her retirement. So thank you all for coming.
Thank you so much. And to give you the telephone number, because I thought it was on our actual presentation, it's not, I'll give you our telephone number. You would call 352-341-6424, option 2. Oh, 5? Where did 2 come from? Huh. They told me 2 last week. Oh. No, please call option 2. That was a Freudian slip, I think. Thanks again, everybody.